Do you still wonder what's the difference between a revocable living trust and a will? Well, I'm Christina Gorakovsky, Trust and Estates Attorney in California, and I'm going to help you sort this out. I am a lawyer, but I'm not your lawyer. So this video is designed to give you some thoughts and ideas to take to your own attorney. So let's talk about the difference between a will and a trust, and then irrevocable or revocable trusts. So a will is a document that says what happens to my stuff when I pass away and who is responsible for making that happen. That's it. That's what a will does. The foundational point, the whole purpose of the will is just that. A trust is different. And almost all of us have a trust already in our day-to-day life because we are a beneficiary of an IRA or a 401k. We've given money to a trustee, the broker, to hold money according to some sort of contract, our 401k plan, or the terms of the IRA rules that are in the tax code. The trustee has to manage that money according to those rules in the tax code, and they can give us the money when we ask for it, as long as we ask for it during the time we're allowed. We also tell our broker what to do when we pass away. A revocable living trust is basically the same thing. We have a trustee, we give our money to the trustee, and we tell the trustee to hold our money according to a contract that we create. Usually the attorney creates it. It's according to the state rules. So 50 states, 50 different rules. And so it's important to know that the trust is a document that can manage your property while you're alive and when you pass away. And usually when you create a revocable living trust, you're the trustee and the beneficiary. You don't have a broker standing there between you and your money. You're also the trustee. Now, it's not necessary that you be the trustee. You can have someone else do the job of managing your money. But most of the time when people create a revocable living trust, they take to both of those jobs, knowing that the trustee job can get changed out. Like if I'm a cashier at a store, I take a break, somebody comes in and does the cashier job. There's still a cashier. Somebody else, it's just not me. So you can always have a trustee. Actually, you always need a trustee, at least in California. It just might be a different person doing the job, following the rules of the contract that was created. Now, another thing that people really will ask me about is they tell me right away, I need an irrevocable trust, Christina. I usually ask them, why do you think you need an irrevocable trust? And they go, well, I don't know what I need. But I think what they mean is that once they pass away, they want their wishes set. They don't want people to be able to mess with those wishes. And so that's not what an irrevocable trust necessarily means. Irrevocable trusts are actually kind of more complex documents, so we're not going to talk about that right now. But the point here is that I think a revocable living trust is a foundational estate plan document. We usually have it as revocable, amendable, changeable by the person who creates it. I hope this is helpful in settling the difference between a will and a trust. I have a 5-part series. I'm going to talk about some other things that I wish people knew before they walked into my office. If you have questions, let me know in the comments and I'll try to answer them.